Business Secretary's inadvertent error sparks renewed scrutiny, a decade-old claim under the microscope. Jonathan Reynolds, the current Business Secretary of the United Kingdom, finds himself embroiled in controversy over a decade-old claim, a claim that has resurfaced with renewed vigor and accusations of potential criminal conduct. The issue stems from a 2014 parliamentary speech where Reynolds, during a House of Commons debate, referred to himself as a former solicitor. This seemingly innocuous statement has ignited a firestorm of legal and political implications, raising questions about accuracy, professional ethics, and the potential for deliberate misrepresentation. The term solicitor in the UK is not just a title, it's a legally protected designation. Only individuals qualified and registered with the Solicitors Regulation Authority, SRA, are permitted to use this title. Any unauthorized use constitutes a serious offense, carrying potential legal ramifications for the individual making the false claim. The controversy reignited recently following accusations from Robert Jenrick, the Shadow Justice Secretary. Jenrick, in a pointed move, accused Reynolds of criminal conduct, escalating the situation significantly. He further intensified pressure by formally requesting the SRA to conduct a new investigation into Reynolds's past claims. This prompted the SRA to revisit their previous inquiry into the allegations. The SRA, the body responsible for regulating solicitors in England and Wales, now has the task of determining whether Reynolds's 2014 assertion warrants disciplinary action. Reynolds, in a statement to The Guardian, attempted to mitigate the situation, explaining that the statement was made over a decade ago and was simply a case of using shorthand during a speech that wasn't even primarily focused on the legal profession. He emphasized that the speech's central theme did not revolve around legal practices, regulations, or the nuances of the law. He described his use of the term solicitor as an inadvertent error, a claim that, while potentially mitigating the severity, nonetheless fails to fully address the fundamental question of whether he intentionally misled the House of Commons. The core of the controversy hinges on the interpretation of intent. Was it a genuine mistake stemming from careless phrasing, or was it a calculated attempt to bolster credibility or project an image of legal expertise? The SRA's renewed investigation will be crucial in establishing the facts of the case and determining the degree of culpability, if any. This renewed investigation will involve scrutinizing not just the speech itself, but also Reynolds's background and professional history to ascertain whether he possessed the necessary qualifications to legitimately claim the title of solicitor at any point in his career. The implications extend beyond the personal repercussions for Reynolds. The case raises important questions about the standards of accuracy and integrity expected from elected officials and public figures. The narrative unfolds with multiple layers of complexity. There's the immediate legal question of whether an offense was committed. Then there's the political dimension, the impact on Reynolds's reputation and standing within his party, and the broader implications for public trust in government. The SRA's findings will be keenly awaited, not only by those directly involved, but by the wider public who have a vested interest in the integrity of their political representatives and the enforcement of professional standards. The outcome of this investigation could potentially have far-reaching consequences, serving as a case study in the balancing act between unintentional errors, perceived deception, and the rigorous standards demanded of individuals holding positions of public trust. The eyes of the nation, and indeed a watchful legal body, remain fixed on the unfolding saga.